All right, so again, we are looking at will construction and interpretation, and this time we are looking at when there is an ambiguity in the will. And the question becomes, is the ambiguity one that should have been discovered from the face of the will, known as a patent ambiguity? Or is it one that really cannot be discovered until the will speaks and you begin to try to carry out the terms of the will? As part of review from construction dealing with ademption and abatement, recall that these rules are applied regardless of the apparent intent of the testator. So ademption is if a specific bequest is not property of the estate, the gift adeems. Maryland says under the identification theory that there is no replacement. The UPC has a special rule that will look to the intent of the testator. What you would absolutely need is facts explaining intent. Something along the lines of testator sold Blackacre and took the funds from Blackacre to purchase Whiteacre because testator wanted the beneficiary to have a better house, something along those lines. Abatement is caused by a number of different problems: debts, liens, creditors, elective shares, things of that nature. We don't have enough to fully fund the will. Whether it be specific, general, or residual, what happens is when there are not sufficient assets to fully fund the estate plan, it goes from residual, so you have no residual. Then in the general bequests category, they abate ratably until there are no general bequests. And then specific, again, they will abate ratably. Remember, a demonstrative bequest is a general bequest to be funded with a specific asset. It is recharacterized between specific and general for purposes of applying the rules of abatement. Right, so what is an ambiguity? First and foremost, think about the fact that we have general rules of construction in wills, just like we have in contracts and many other areas of law. One that might be unique to you is the fact that to the extent someone put together a will, there is a presumption that that will is designed to avoid having property pass by intestate succession. All of the other rules you've probably been exposed to before, plain meaning rule, and we look at these rules in determining whether or not an ambiguity exists. If we can carry out the plain meaning of the rule, then we need not go to the ambiguity, classifying it as latent or patent, and applying the extrinsic evidence. One thing that is confusing with respect to ambiguities is oftentimes we look to extrinsic evidence, like a dictionary, for example, just to come back and say there is no ambiguity. So don't get confused about the extrinsic evidence piece, because oftentimes the courts will look outside the will to come back and say there is no ambiguity. If you find that some word or words of the will are ambiguous, you should classify them as either latent or patent, because the extrinsic evidence rule that will allow you to shed light on the testator's intent. There are limitations. We can't say what the testator intended. We can shed light on the words. All right, so think about the extrinsic evidence that you might see. A prior will would be extrinsic evidence. A birthday card would be extrinsic evidence to shed light on the testator's intent. Let's look at a limitation. I hereby leave $10,000 to my sister, Chrissy. Well, there's absolutely nothing ambiguous about that as long as the testator has a sister, Chrissy. All the extrinsic evidence in the world should not be able to modify that provision, that general bequest of 10,000 that can be carried out as written? How about a situation in which Kim Kardashian's will says I leave $1 million to my sister? On its face, that does not look ambiguous, but when we go to carry out the terms of the will, we realize that the testator had multiple sisters, and that's where we would need to get to the extrinsic evidence. Is there anything ambiguous about a provision that says I leave my sister Chloe? Leave her what? Can we get to the extrinsic evidence? Is it the diamond ring? Is it the $1 million? What is it? So that would be a situation in which it is patently ambiguous. That should have been discovered from the face of the will. We don't need to carry that out. And why does the court limit the extrinsic evidence to the extent that the ambiguity is a patent one? Because we would never know. Any and every Khloe Kardashian could hire the best lawyers to show it was the $1 million, the ring, and everything else. Okay, there's really no limits and no boundaries, and that's what concerns the court. Estate of Carol. Is there anything ambiguous about my nieces and nephews? What does the court find? Is it ambiguous or not? Gibbs v. Robert W. Krause. What's the ambiguity? The will says to Robert J. Krause of a specific address, 1%. There's one person that fits that description. Why shouldn't the property be left to Robert J. Krause of 4708 North 46th Street, Milwaukee, Wisconsin? How does the court get to the extrinsic evidence in Gibbs? It is under the plain meaning, should have been carried out as written. How about Britt v. Upchurch? What's the ambiguous term? What's the extrinsic evidence? Why is the attorney affidavit not allowed? My residence. Well, that's not so ambiguous, except for when we try to carry out this will, the question becomes, did my residence mean lot 36 or lot 36 and 37? And the attorney wants to say it means only 36, but that's the limitation. We're not going to listen to someone getting on the stand and telling us what the testator intended. Patent, again, obvious from its face. Why are the courts reluctant to reform them? Why won't the courts fill in the blanks? Why limit extrinsic evidence in terms of a patent ambiguity? Take a look at NUP. That's a patent ambiguity. The courts would not entertain extrinsic evidence to try to get the property to Richard L. Knupp, who was named as an executor in Provision 8th. Keeping in mind, Provision 6 is where the residual was distributed to the legatee in 8, but 8 only named the executor. District of Columbia gets the money because this particular testator had no heir. Why are the courts reluctant to reform wills? What will it take for a court to reform? And are the reformation rules the same for wills and trusts? Very difficult to reform a will. Why is that?